Jharkhand. Good afternoon, one and all present. Johar greetings to all. That is how we greet in Jharkhand. I am Nikhar Baranwal, Assistant Public Prosecutor, serving in the state of Jharkhand, rich in humble people and minerals. Of course, we all know. My group D has put a lot of efforts in confining ourselves to our different topics. So I am just going to constrain myself towards the role of prosecutors. So we prosecutors are middle berth. Like just in the train, we are the middle berth between the police investigation agency and the judiciary, right? From the filing of charge sheet, the police works is mostly completed. And then until the judgment is pronounced, every entire duty, how the trial is going to be conducted, how prosecution is going to be conducted, what petitions to file, what rejoinders to be filed, how we are going to discover the truth and let it shine through the court is the duty of the public prosecutor. We move the court through all possible petitions. Like as judges, you must have received, as prosecutors, we have filed, as investigation agencies, you must know that how rejoinders, applications 311, 319 and 242 subsection 2, where on application of the prosecution, the magistrate may summons any of the witnesses to ensure its attendance, produce any document or thing in favor of the trial. Then filing of documents to proving them. Very important, immensely important step in the trial, that prosecutor has the entire discretion as to what documents are going to prove what facts. And this is upon us. We all are aware of section 165, 166 of Evidence Act. We have to assess the importance, the significance of the documents, and that is how we file to the court, and that is how we substantiate with judgments, with deposition of witnesses, and that is how we are able to prove the guilt of the accused beyond reasonable doubt, as it is required for the relevant judgment in our favor. Then examination of witnesses. See, I see examination of witnesses as an art, right? Cross-examination is not the only art that we see in the trial. We have people of India who lack education, who lack comfort, who lack security, and then complete devoid of legal procedure, the legal acumen, the legal knowledge. And then we are bound to get illicit truth from them before the court, where they are unaware of COAT court and completely unaware of COURT court. And those witnesses have to explain, they have to explain as to what they have undergone. See, the problem also lies that they are not even able to, as for sexual assault, let's talk about sexual assault cases. Women are not able to say that they have been raped. Sometimes they just say, "Sir, galat ho gaya mere saath." How does the court know? How would the court know whether it was just outraging modesty or it was actually rape? Witnesses are not able to express themselves, and that is where the heavy burden lies on the shoulders of prosecutors, because then we have to make them speak what they've undergone, and that takes a lot of courage. I can tell that. Then we are prosecutors and not persecutors. Persecutors, we don't have a responsibility of let any accused go punished. We are not here to hang them or put them into jail. We are only helping the judiciary to discover the truth. We are only aiding them in the entire process. And for that, we have some tools. I have generally found in various discussions that people say the depositions are our weapons. They are not weapons. We are not fighting in the court, my friends, ladies and gentlemen, honorable dignitaries. We are not fighting in the court. We are aiding the court. We are forming something. We are, if the punishment is there, if the accused goes punished, this is because he has done some wrong. So these are our tools, these depositions, these evidences, these are our tools, and we are into forming some structure. Then prosecutors are the gateway to criminal justice system. The accused gets all his right to engage a good counsel. But for victim, we are the counsels. We represent them, and state has appointed us to showcase our best advocacy skills and always put the best foot forward. And therefore, heavy responsibility again lies on our shoulders, because that requires legal acumen, a very good experience, and a humble heart and empathy. Proactive prosecution, yes. See, our duties are nowhere defined. They are not in the CRPC. Sometimes we gather it from police manual, let's say. But we need to understand that proactive participation in the trial, making witnesses speak, sometimes helping them, tutor them, and then comfortably making them speak before the honorable court, and then sometimes get their demeanor also record and put it, let it shine in the eyes of law, in the eyes of court, so that they also record it. Because it is us who is understanding the barrier in the language, barrier in the understanding, barrier in the gap of understanding between us and the witnesses. We have to make it highlight before the court to win our case. And then appreciation of evidence during arguments. I understand the defense counsel only has maybe 5-7 cases in the entire day, but as prosecutors, we literally have to deal around 50 court records every day. And sometimes we have 10 witnesses to chief examine and then 4 arguments in another court. I understand we cannot be expected to do 100%, but then yet we should try our best efforts. We should endeavor that during arguments we are able to appreciate the evidences, because we have read Evidence Act. We know how ordinary transactions, the regular courses, the conduct, the motive, every smallest of the circumstances, how they are helpful in forming the chain. That chain is complete, which is specially mentioned in the Birdi Chand Sharda case, where the circumstantial evidences need to form the whole chain. So that appreciation of evidence must be there, so that we are able to prove our case beyond reasonable doubt. Then our duty does not end when the acquittal or conviction is announced. Our duty goes beyond. We, as advocates of a victim, have to inform them about their rights to appeal and help them in filing the appeal and then the way forward. Lastly, initiate the victim compensation scheme before the court. The rights that victims have got under section 357A CRPC, we are the ones who initiate it. We are the ones who write to the court that the victim deserves compensation. We are the ones who say that under the doctrine of parens patriae, where the state is the guardian of its people, we are to put it forward to the court that they deserve some compensation. And at last, I conclude my presentation here. Johar once again. Thank you.